Hello, my name is Caroline Palmer, and I'm the Public and Legal Affairs Manager at the Minnesota Coalition Against Sexual Assault. Today I'm going to talk to you about mandatory reporting. As you already have learned, the Violence Against Women Act allows you to share a survivor's information if it is required by state statute. In Minnesota, the primary statute that falls under this exception is Minnesota Statute Section 626.556, the Mandatory Reporting of Child Abuse Law. Under this law, domestic violence and sexual assault advocates are considered mandated reporters of child abuse. You must make a mandated report when you know or have reason to believe that a child has been neglected, physically abused, or sexually abused. These terms each have a very specific definition in the mandatory reporting law, and it is important to know what they cover and what they do not. I will go over them now. First, there is neglect. You must report neglect when someone responsible for a child's care, usually a parent or guardian, but also other adults such as family members, teachers, coaches, or so on, do not appropriately care for a child. This includes not providing food, shelter, medical care, education, or other necessities to the child. Additionally, if someone fails to keep a child away from conditions that endanger the child's physical or emotional health, such as chronic alcohol and drug use, it is also considered neglect. Failing to leave an abusive relationship is not neglect under this law. Second, there is physical abuse. You must report physical abuse when a person responsible for a child's care inflicts physical injury, mental injury, or threatened injury on a child, and the injury is not accidental. Reasonable and moderate physical discipline is not considered physical abuse. Third, there is sexual abuse. You must report sexual abuse when a person responsible for a child's care or a person with a significant relationship to a child, which is a parent, guardian, relative, or an adult living in the same home as a child, or a person in a position of authority over a child, basically anyone who has some sort of responsibility to care for the child, which could include a parent, guardian, doctor, coach, teacher, and so on, commits a criminal sexual act against a child. Sexual abuse also includes sex trafficking, but only if the trafficker falls into one of the relationship categories that I just described. For example, if a 17-year-old has been trafficked by their 19-year-old partner, who they do not live with, you are not required to make a mandatory report. I just did a very broad overview of neglect, physical abuse, and sexual abuse. It would take too long to go into more detail in this video. The mandatory reporting statute with full definitions of these terms is included in this week's handouts. Please read it and keep it for future reference. If there is a situation where you are required to make a report, you have 24 hours to make the report to your county, child protection agency, or law enforcement agency. If you do not make a report when required, you could face a criminal penalty. If you must make a report, it is very important that you tell the survivor before you call child protection or law enforcement. You should tell the survivor what you will say in the report and explain that you are required to make the report by law. You should also speak with the survivor about their options once the report is made. Also, be sure to tell survivors when you first meet with them that you are a mandated reporter and provide periodic reminders during your service. Well, that's all you need to know about mandatory reporting in Minnesota. Remember, Minnesota's mandatory reporting laws are very specific about when child abuse needs to be reported. In the future, if you need assistance on mandatory reporting issues, feel free to call MNCASA or MCBW. Also, most importantly, remember that even when required to make a report, your primary job is still to support the survivor you're working with. Thank you.